Welcome, everybody. Now, as some of you may be wondering what ICRC is, it's a neutral, impartial, and independent humanitarian organization. And we have a mandate to help and protect people affected by armed conflict and other violences. Part of our mandate is to promote international humanitarian law, which is why we're here. Now, this event, the IHL International Humanitarian Moot Competition, is purposely designed to create awareness of the international humanitarian law amongst students. This event will last 2 days, from today to tomorrow, 15th of October 2021. And yes, so without further ado, I would like to introduce the judges that are present here with us. Feel free to clap your hands or give them smiles in masks, they can see them. So we have Dr. Charity Wibabara from NPPA, National Public Prosecution Authority. Thank you very much. And with her, we have Omorungi Providence from Minijust, the Ministry of Justice. Right next to her, there's Maître Waingana Magi. And we have Maître Dahayo Calixte. We also have Mr. Nirurugo Jean-Marie Vianney from the Financial Intelligence Center. Thank you very much. And we also have members of the National Moot Court Organizing Committee, beg your pardon, Dr. Foctoise Vigiriman from Ines Ruhengeri. And Emmanuel, the lecturer from ILK. Thank you very much. We also have our other important guests, the Mootas. We have Mootas from Ines Ruhengeri, and we have Mootas from UK. Okay, let us give them a round of applause. Ines Ruhengeri. Thank you for representing. We also have Mootas from University of Kigali. Thank you very much. And we have Mootas from UR. Nice to see you. We also have Mootas from ILK. Thank you very much. Now, without taking much of your time, we'll have Dr. Fructoise to come give us his remarks. Thank you very much.
Good morning, everybody. Thank you, Rhoda, for your introduction. Dear head of ICRC delegation, Kigali, dear participant, distinguished guest, I would like to start by presenting the background of this event. The idea of moot court competition came up from the third faculty roundtable lecturers of international humanitarian law held here in Kigali and organized by ICRC. It was in 2015. This is the 5th moot court competition organized in a partnership with ICRC and law faculties here in Rwanda. So this is the rare occasion where law schools or lawyers from different areas, lecturers and others, will get updates and shape their teaching methodology or adaptation to the new dynamic of EHL, specifically the protection of cultural property during armed conflict. We acknowledge the support from a Red Cross Society here in Rwanda. Without delay, I would like to wish success, good luck to our student, to our Mooters, our participant. Thank you very much.
Good morning to you all, and I wanted to wish you a very warm welcome in this fifth edition of the Moot Court competition in Rwanda. In particular, I would like to thank the judges that accepted to dedicate 2 days of their valuable time for this competition, and it shows, I think, the mutual interest that the Rwanda government and the ICRC have for the promotion of IHL. And I would like to welcome as well all competitors. I would like to wish you good luck. I hope you will have the opportunity to show the best of yourself. Thank you very much.
So I will talk about the aims of this event, and then we'll see how, what do we need as a national Moot Court competition in Rwanda, why do we have, and then I will give you, or I'll share with you the impact of teaching international humanitarian law here in Rwanda. Next. So basically those are the aims of this national IHL Moot Court competition in Rwanda that we organize in collaboration with our 5 schools of law, namely University of Rwanda, IRK, University of Kigali, and in Iraq. The aim of this event is to enhance the online student knowledge and applicability of IHL by converting theoretical knowledge into practice skills. So why do we need in Rwanda? Why do we need this event? Why do we need this platform in Rwanda? First, it's a unique network where an opportunity for both students and lecturers where we share skills and build our network. Because I hope that for our Mooters it will be the first time to face some of those people, I mean, our respect for judges. It's a good chance. We have private lawyers, we have prosecutors, we have judges. Maybe tomorrow you may go and join Bayingana in her cabinet. Why not? So this is a good chance. So market yourself. Is that okay? So second, we increase the links between the academia, policymakers in these countries. IHL rules are taken from mere principles in the books to realities in everyday life. So we've been studied what we have in these books, Geneva Convention and the AEP's additional protocols. So it is indirect promotion and application of IHL by professors and students. This is a good platform for you to start practice what you've learn and put in practice by defending the Moot case, of course, basing what you put in your memorials. Thank you very much for your kind attention.
Today, the 14th of October, 2021, the pretrial chamber of the International Criminal Court is presiding over a criminal matter of an international criminal nature between the prosecution and Major General Dragon. The chamber is presided over by myself, Charity Wibabara, the principal judge, and my colleague judge, Dahayo Karist. Is the prosecution present? Is the defense present? Each of the parties shall have 20 minutes of presentation, of opening statement, and then for the prosecution, presentation also of their charges, and the defense shall equally have 20 minutes of presentation of their opening statement and rebuttal.
This honorable court, again, apart from the ratione material jurisdiction, it also has the ratione temporis jurisdiction. My lord, as I was saying, this case is admissible to this honorable court because pursuant to Article 17, item 1, from A, B, and C, it states that this honorable court will have jurisdiction as long as there is no state that has investigated and prosecuted the case. My lords, pursuant to the facts within the case, it's not even there that there is any indication of a state investigating or prosecuting the alleged crime on Major General Dragon. To all movables or immovables of great importance to everyone. My lords, allow me to talk about the elements which constitute this crime. So Major General Dragon directed an attack. Alabasta Armed Forces under the command of Major General Dragon directed an attack towards the objects which were protected.
What is your understanding with reference to the IHR and also other related, the Rome Statute and everything? Is the protection absolute if the cultural objects are used for military objectives?
For the limitations that you're talking about, pursuant to Article 1 of Article 4, Roman 1 of the Hague Convention, it states that the protected objects should not be subject of attack. But however, this may be waived as long as the military objectives.
Your Excellencies, may it please the court. My name is Gilan Irahoza, and I'm here to continue with our further submission on the 3rd, 4th, 5th count. So, my lord, without any further ado, Your Excellencies, Major General Dragon is criminally responsible for directing attacks against civilian population, which is protected, which is punishable under Article 8(2)(e)(1). And the elements here are satisfied. First of all, there has to be an attack for you to confirm that this crime can be charged by this honorable court. And also, the attack was directed against the civilian population, my lords. Your Excellencies, according to the facts, we know that Alabasta Armed Forces went down on 19th June 2013 to attack and to actually direct an attack against the whole population, whether the combatants are involved or like without excluding the combatants or the civilians. So they did an indiscriminate attack towards the whole population recklessly. And also, I'm going to answer your question about the elements of the crimes against humanity. I talked about crimes against humanity of extermination. And Your Honor, the first element we should talk about is that the perpetrator killed the person by inflicting life conditions which are calculated to bring about destruction of part or whole of the people who are populated in a particular area. So that particular area is the province of Kuru, my lords. And also, the second element, Alabasta Armed Forces bombarded the whole city of Verdansk, targeting the whole civilian using indiscriminate weapon. One of the different methods of killing, inflicting life conditions, denying humanitarian aid. My lady, what happened is Major General Dragon denied humanitarian aid by giving a nil-grounded, excuse that there was no control over the possible diversion by the LLAs, by the Legion for Liberation of Alabasta. And then that happened. And he denied the humanitarian aid towards the people of Kuru. As well, we are going to mention our third element, which was the conduct was part of the widespread and the systematic attack. Your Excellencies, what do I mean by a widespread or systematic attack? A widespread is a large-scale nature of a conflict, while a systematic attack refers to the organized nature of act of violence in probability of random occurrence, referring to Cordic and Sarkis case, my lords. For the fourth element of under the crime of extermination, my lord, excuse me, the conduct was intended to be part of the widespread attack against the civilian population. It was not only intending the LLAs who were supposed to be the combatant, but it also went beyond to actually the citizens as well.
Now it's time for the defense to make your opening statement and your defense in the next 20 minutes. Yeah.
My name's Matinou Samuel Frank, and I am here with my co-counsel, Umuto Niwase. Kuru, a province of Wanu, serves as the base for legions for the liberation of Alabasta. For the past 80 years, Kuru turned into a safe haven for military training, manufacturing of weapons. On 5th June 2013, the state of Alabasta declared that a military campaign under the name Operation Anchor of Stability would take place on 10 June 2013. Moreover, the jurisdiction of this court is challenged by the defense on the basis that Article 21 of the ICC, the court shall first apply the status, the elements of the crime. Any of the enumerated acts found in Article 7, which include the widespread or systematic attack directed against any civilian population with knowledge of the attack, from this we can identify 5 general elements. 1, an attack directed against any civilian population. 2, a state of organizational policy. 3, the widespread or systematic nature of the attack. 4, a nexus between the individual act and the attack. And 5, the knowledge of the attack. For the element of a direct attack, it means that the civilian population must be the primary objective of the attack and not just an incidental, haphazard victim of the attack. The civilian population has never been the primary target of the Operation Anchor, which is further evident in the case through the action of the defendant when he requested that civilian population should evacuate the city of the Verdansk in order to spare them from hostilities, a request which around 90,000 people respected. It is thus the reason why the actions of Major General Dragon cannot be considered as crimes against humanity. In addition, basing on Article 19 of the Geneva Convention relative to the protection of civilian persons in the time of war of the 12th August 1949, it is provided for situations in which civilian hospitals may lose their protection status in case they are used to commit acts that are harmful to the enemies. Hence, the LLA members used the hospitals and schools as grounds to attack Alaba armed forces. This automatically removes the protected status of those places.
Before you hand over to your co-counsel,
Yes.
Counsel, during your presentation, you mentioned that the Alabasta Armed Forces had
Yes.
no option than to bomb the cathedral.
Yes.
How do you connect that to IHA rules regarding protection of cultural heritage objects?
Related to cultural heritage, I would say that the Geneva Convention in the additional protocol 1 speaks about the fact that whenever in NIAC or in situations of a NIAC, it is impossible or it is not possible for an armed group.
So the defense also believes there was a non-international armed conflict, right?
Yes, the defense believes it was a non. It is a non.
Continue.
Yes, as far as properties of the civilians or hospitals or protected stuffs are used by any enemies, they become automatically military objectives. And I mentioned under Article 52, paragraph 2 of the Additional Protocol of 77 that attacks shall be limited strictly to military objectives. And it is clear that all of those civilian objectives turn to become military objectives.
Your co-counsel may proceed with the
Yeah.
defense.
Thanks, honorable judges, my co-counsel, and the prosecution team. If it pleases the court, I would like to proceed with the whole crime which has been submitted by the prosecution by adding on what my co-counsel Samuel has talked about. With regarding on the issue of the willful killing, let it be known by the court that there was no any kind of willful killing, since the target was only on LLA, it was not directed against the civilian population. The Alabaster armed forces were fighting with LLA only. They were not targeting the civilian population. With regarding also on the issue of bombing the cathedral as it has been submitted by the prosecution. The cathedral was being used by Commander Sabo. Let it be known that Commander Sabo was in that cathedral, and Commander Sabo is a member of LLA who was giving orders on what to be done. So the cathedral was using as an infrastructure to contribute to the military attack of LLA by launching an attack on LLA. And this shows that the cathedral was not in the protected property since it was contributing to the military objective of LLA, why it should be protected. First and foremost, the defense requests the court the following. Find that it lacks jurisdiction and competence to hear the case at hand, as it has been raised by my co-counsel Frank Samuel, and also to declare that Major General Dragon did not commit any kind of violation of the ICC statute, and those charges that have been submitted by the prosecution should be dismissed due to the lack of evidence, since there was no any kind of violation which Major General Dragon did. I arrest my case.
You talked about command responsibility. How do you want to convince the panel of judges before this court that Major General Dragon did not have control over his subordinates? Because in your presentation, at one point you believe the subordinates committed crimes or did certain attacks, though you justify them. But do you want to tell this court that he did not exercise effective control over his subordinates or not? How do you justify that as the commander or as the superior?
The command, let it be known by the court that the command, Major General Dragon, had not any effective control over the crime which the prosecution have submitted, since the whole control of the city was on LLA, and the members of the Alabaster Armed Forces with the Major General Dragon, the only way they was doing is to fight against those people of LLA. This shows that there was no any kind of effective control which Major General Dragon had over his subordinate.
I just need you to justify your use of facts and law. How he made the choices of means and methods. I need to understand with respect to fundamental principles of IHR.
I would like to talk about the Syracuse principles, which allow state authorities to build in emergencies restrictions on rights. And these are only justified when the support of a legitimate aim and when the support is of a legitimate aim and is provided for by the law under the Geneva Conventions and the additional protocols and is strictly necessary. That is the element of proportionality and for a limited duration and which is subject to review against the abusive applications.
When you ask the question about the constructive control, they actually, failed to prove that the constructive control was impossible by saying that, quoting the statement that co-counsel Samuel stated, he said they had no choice but to kill. What proves that there was no other alternative? Yes, Your Honor. And also, we would like to mention that there was a failure to actually respond to what the prosecution was accusing of them, the charges that we brought up, by bringing out other crimes, which shows that the defendants they agree with what we have said and also brought in different crimes. So they brought in willful killing as a war crime, as a crime against humanity. And they were not able to give elements against what we have provided, elements against what is in place already.
I'd like to proceed with requesting from the prosecution a proof of how they know that Major General Dragon was willing to kill first. They weren't clear on that. And I wish they followed me very well as I was talking about the war crimes. As Major General Dragon is being accused of war crimes under Article 8, which is willful killing. I would like to mention to the prosecution that the Geneva Conventions and the additional protocols mention that whenever civilian objectives are equally a target of an armed international conflict, they automatically become military objectives. I would like to clarify Major General's intentions. If we are talking about him being willfully killing people, his intentions were not to kill. His intentions was to restore peace and stability.
The prosecution have submitted that Commander Sab was in the cathedral, helping people which they have been together for 8 years. He was actually there for sheltering there in order to launch an attack on the armed forces of Alabaster. Thank you.
After carefully following the presentation of the charges and the defense submissions, the court would like to dismiss this hearing for further deliberation of the subject matter.
Yeah, good morning and welcome to before this trial chamber, pre-trial chamber of the International Criminal Court. We have the prosecutor against Major General Dragon on this case. So, as we have lot of time, I will call the prosecutor to present his submissions before the honorable judges. Thank you.
I'm Counsel Buziji Derrick, and together with my co-counsel Gaitesi Phoebe, we represent the prosecution. And the case before you, it is a case that was initiated by the prosecution against Major General Dragon, who is the accused in this case. And if you grant me latitude, allow me to take you through the brief characteristics of our submissions that we advanced before you. We are going to assist the court in showing that the intervention of Alabaster's military on the territory of Wanu, without the latter's consent and the existence of an armed conflict between the former and the LLA, is a clear indication that the conflict was an international armed conflict, but with a parallel non-international armed conflict. If you allow me latitude, my lords, allow me proceed by starting with the issue of admissibility, under which we are going to tackle two key components. One is the principle of complementarity, and secondly, the other is the gravity threshold. Proceeding on, my lords, tackling the issue of the nature of the conflict. The nature of the conflict at hand is an international conflict, but with a parallel non-international conflict. And therefore, we invite you to the facts of the case, and we request this honorable chamber that the mere evacuation of the state of Wanu on their border post with Alabaster should not be taken into consideration to tantamount it to consent. Proceeding on, my lords, both the RULAC and the ICRC meet on one particular issue, that the existence of an international armed conflict does not eliminate the existence of a parallel non-international armed conflict on the same territory between the armed group and the territorial and the attacking state. If you allow me invoke the Haradinaj case, which sets criteria that have to be met in order for a non-international armed conflict to come into play. The first issue that was raised in that case is the identity of parties. My lords, to invite you to the facts of the case, the non-international armed conflict at hand was between the LLA, which is an armed group, against the state of Alabaster. Further still, the LLA has been occupying the oil-rich province of Kuru for over 8 years, for which they used to manufacture weapons and even carry out trainings. To invite you to the facts of the case, it should be noted that Major General Dragon ordered an indiscriminate attack on a civilian city. And he ordered the use of indiscriminate weapons, many of which are even prohibited explicitly by different conventions.
Thank you, Your Honors. Counsel Kaitesi Phoebe, as my co-counsel introduced earlier. Allow me proceed to the second account. The accused should be tried and found liable for the use of starvation as a method of warfare, provided under Article 8 2B, Human Numeral 25, and Article 25(3)(a). To start by proving the accused laws, the accused put the city of Vendaska under siege After 45 days, my lords, it was reported by Moot, International Human Rights Organization, that civilians 120,000 were in their need of food, water, medical supplies, pursuant to paragraph 6 of the facts of the case. To prove the accused laws under Article 25, 3b, my lords, the accused ordered indiscriminate attacks using indiscriminate weapons, which in fact heavily damaged the cultural property, which is the cathedral. That is pursuant to paragraph 11 of the facts of the case. Going on to prove the mens rea, by using weapons that cannot be aimed at a military objective or whose effects cannot be limited, it was obvious that in the ordinary course of events, injury would occur on the protected property. Since he knew of its status, no wonder, pursuant to paragraph 12 of the facts of the case, his order not to bomb what was left of the cathedral is a prima facie proof of his knowledge of the status and existence of the cathedral. To prove the mens rea, the accused had the subordinates under his control, and thus he ought to have known that they were targeting the cathedral, so he could prevent, or at least they, in fact, did the bomb it, so he could punish. But nevertheless, he did nothing. Therefore, we submit to you that he should be held criminally liable for failing to prevent the attack on the cathedral or punish his subordinates for the attack under Article 28A, paragraph Roman numeral 2 of the Rome Statute. That the ICC has jurisdiction over the case. Secondly, that the case is admissible. And lastly, that there are substantial grounds to believe that Major General Dragon is liable for all counts. We therefore request for other reliefs that may be for the prosecution. We rest our case, my lords.
Thank you. Thank you. Now, defense, you have 10 minutes for.
Article 8, 2E4, the war crime of attack on protected objects. Article 8, 2B4, the crime of excessive incidental death, injury, or damage, Your Honors. And Article 2, Article 8, 2B, XXV, starvation of civilians and deprivation of access to objects and deprivation of access to objects indispensable to their survival. Your Honors, if it pleases the court, allow me to clearly define what a NIAC, or non-international armed conflict, is. Your Honors, in the Lubanga case, the trial chamber decided that a NIAC is a protracted violence between government forces and organized armed groups. In the Rome Statute under Article 66, paragraph 2, Your Honors, according to the dissenting opinion of Judge Anita Osaka on the Thomas Lubanga case, conviction should only occur unless all reasonable doubt, all reasonable hypothesis based on the evidence indicates guilt, and the prosecution failed to produce sufficient evidence to establish substantial grounds to believe that the accused committed such crimes. Your Honors, if it pleases the court, allow me to call upon my co-counsel, Ngoga Samuel, to proceed with the counts, defense for the counts.
Thank you, Madam President. Your Honors, I'm going to be continuing with the war crime of attacking protected object, especially when the prosecution mentioned the attack on the St. Augustine's Cathedral. Your Honors, the protection no longer existed. According to customary international law, rule number 38A, a special care must be taken in military operations to avoid damage to buildings dedicated to a region, art, science, education, charitable purposes, or historical monuments. Your Honors, furthermore, according to the Pavre-Strugar case, in circumstances where protected buildings are designated as military objectives, the buildings would then lose their protected status. The military necessity, it was important that our Basta armed forces attack the St. Augustine Cathedral along their Commander Sabo and the members of LLA. Your Honors, it's evidenced by the facts that found in the case at hand, especially in paragraph 2, that after the attack, It was confirmed that Commander Sabo had died alongside the members of LLA. What happened next is that there was the conquest of the city of Ndaska and peace returned in the province of Kuru. Your Honors, there was no intention of attack a protected object. Your Honors, according to the Rome Statute, Article 30, a person has intent where in consequence that person means to cause that consequence or is aware that it will occur in the ordinary course of events. It is allowed, and there is this inevitable, unfortunate truth about collateral damage. But in this case, the defense is not saying this went as a collateral damage, because in this case, the St. Augustine Cathedral was a military objective, and we had right. Thank you, Your Honors. Allow us to continue to the prayers. So, thank you.
Thank you. If it pleases the court, allow me to proceed with the prayers. The defense humbly submits, requests this honorable court, this honorable trial chamber to dismiss the charges under the Rome Statute against Major General Dragon for the following reasons. There are insufficient grounds to confirm charges against Major General Dragon, indicating that Major General Dragon is not criminally liable as per Article 28(2)(b)(4), and Major General Dragon is not liable under Article 8(2)(b), XXV, starvation of civilians and deprivation of access to objects indispensable to their survival. Your Honors, I rest my case.
I will ask the prosecution the reason why they have brought the issue of admissibility in their submission. Can you elaborate more on the admissibility issue you have raised in your submission?
In particular, the issue of admissibility, as you requested us to clarify, admissibility, we elaborated it in the context of complementarity principle because it was respected in this particular case since there was inaction from 2013 from the concerned states. They never did anything to date, actually. They never did anything. And therefore, we concluded that the issue of complementarity was respected, and we submitted before this honorable court to confirm that there was unwillingness on the side of the concerned states. And the third question that was established in that case was whether the accused is most responsible by his actions and omissions, under which we proved invoking Article 25, under which the accused gave orders, and Article 28, under which the accused failed to prevent or even punish after the commission of the crimes by their subordinates. Respectfully, my lords, I don't know if I've answered you. Okay, thank you.
Thank you very much. Maybe before we continue with the rebuttal questions, excuse me because there was some misunderstanding. I think we cut you short, so you still had like 8 minutes. I added you 2 minutes, so you can just still go on your submission for the rest of 9 minutes.
2 elements are missing because the conduct did not take place in a context of international armed conflict, as we have explained it, my lord. There was a non-international armed conflict. We didn't see in the facts at hand, in the case at hand, the involvement of WANO, either be it a confrontation, either be it as a sovereign state making a statement. This is a sovereign state, and for them saying silence, please, they have a structure. Even an armed group had a structure, and the representative, Commander Sabo. So now we are not buying the idea of a whole country not making a statement, yet another country has violated their sovereignty. People evacuated, now he knew about the numbers, and now then he applied the principle of distinction to the letter. My lord, with the time interest, I would like to hand over the mic to my co-counsel, Denise Isimbi, to continue.
Your Honors, under the Rome Statute, it is stated as the war crime of excessive incidental death, injury, or damage. Your Honors, defense contends that the prosecution has failed to clarify the exact counts they are charging with Major General Dragon, but as defense determined to walk Major General Dragon out of this trial chamber a free man, we shall defend ourselves. Your Honors, the perpetrator did not launch any attack. Defense submits that the elements of crime were not fulfilled since there was no conduct that was committed as part of a widespread or systematic and direct attack against a civilian population. Article 8(2)(e)(4), the war crime of attack against protected objects. Article 8(2)(b)(4), the war crime of excessive incidental death or injury or damage. Article 8(2)(b)(xxv), starvation of civilians and deprivation of access to objects indispensable to their survival. And Article 28A of the Rome Statute as a command responsibility. Your Honors, I rest my case.
Referring you to the facts of the case, they left after the 5 days, not within the 5 days that he had given. That shows that he never even intended. The days weren't ample at all. Further still, they even left their properties. Still within the facts of the case, none of them left with their properties. None. They left their properties in the city of Vendansky. These were people who were crippled. They could not leave the city. These are people that IHL cares much for. So disguising in the context of 5 days, it was really not ample at all, and it shouldn't be a ground.
I would like to compliment my co-counsel saying that on the question about the weapons used by LLA, claiming that they couldn't afford the weapons that are allowed under IHL. It's prohibited under IHL to use weapons that are not directed at specific military objectives or whose effects cannot be limited. So he couldn't invoke that these weapons, that they can't afford weapons that are allowed. If not, they can refrain.
Where will humanity at the end of the day end? Because these are internal matters of states. Who knows much about the Alabaster budget? These are internal matters. So every state will be coming and claiming that our military budget cannot afford more precise weapons. But then if at all that is the way to take, my lords, it will be a risk to humanity. So we're calling on you to stand with us and stand with humanity, because that is what we stand for. Thank you very much.
I have a question for the defense team. You claim that in your defense you say that the St. Augustine's Cathedral was used as a military object, and that gave the general an impossible choice, and therefore it lost its protection that is given in the law. How do you explain the continuation of bombing 3 days after the cathedral was bombed? Does that highlight another intention? And what is your legal analysis for that, and what does the international law say about that?
After the attack of St. Cathedral and the death of Commander Sabo, there was peace. No more bombings took place, as you can read it. After the confirmed death of Commander Sabo, Major General Dragon depicted the conquest of Vedaska and the decisive step in victory of Order of Attila. This war lasted all these days because our LLA was a strong armed group.
ICRS actually agreed that it is true that even if you enter the territory of another in pursuit of an armed group, it is possible that there may be other people of that territory that you are attacking. In this context, it is obvious that they were on the territory of Wanu. There was a population of Wanu on that territory in the city of Vendansky. So it is very possible that since we have civilian casualties, since we have civilians who were directed attacks at, it is very obvious that there was an international conflict based on that issue of attacking the population, which is also a constitutive element of a state. The order should have been given by the commander. In this context, that is not the issue. So military necessity can't be invoked pursuant to Article 6 of 1999. Further still, they should have also given an advance warning before making an attack. Respectfully, my lords, allow me, I invite my co-counsel to proceed briefly. Thank you very much. Okay, thank you.
Thank you, Your Honors. On the issue of proportionality, would like to invoke Article 51, paragraph 5b of the 1977 Additional Protocol 1, and Article 25 and Article 28, both causing civilian loss of life and injuries, as it is stated in the facts of the case. More also, the learned friends from the defense are all use of indiscriminate weapons that cannot be directed at a particular military objective.
Who was a combatant and who was a civilian? These were people who have been like infiltrated by LLA, and for example, they were asked to leave the city and some refused because they have pledged their support and love for LLA armed group. According to Article 52 of the Additional Protocol 1, attacks shall be limited, I quote, attacks shall be limited strictly to military objectives. They also say something about giving a warning. Your Honors, we are pleading and we are requesting this honorable court to establish a strict mens rea to prove that Major General Dragon had an intention of attacking the St. Augustine Cathedral prior to it being a military objective. As a rational general, we invoke and we are pleading this honorable court to establish a strict mens rea and to request a strict mens rea from the prosecution. Thank you.
We thank you very much. You still have other rounds to do. And go and consult again, and we are just the judge are going to deliberate, to do deliberation on the case. Thank you very much. Good morning, everyone. A warm welcome to before this pre-trial chamber, where you are meeting today to hear the case, the prosecutor against Major General Dragon, before the International Criminal Court, pre-trial chamber. So, without due, Counsel President of the prosecution, please present yourself, and you have 20 minutes to present your submissions. And also the defense team will have also 20 minutes to respond.
Good afternoon, my lords. Representing the Office of the Prosecutor, my names are Counsel Umuhuza Faraja Judith. I'm with my co-counsel Ilahoza Gilen. My lords, if it pleases this honorable court, I would like to begin with preliminary matters. This honorable court has the Ratione Material Jurisdiction under Article 5B and C of the Rome Statute. The nature of the conflict is a non-international armed conflict. My lords, with reference to the case of Tadiq, paragraph 70, it states that a non-international armed conflict, my lords, there are two thresholds that were meant for the conflict between Alabasta government with LLA's Legions for Liberation of Alabasta to be called an armed conflict. Referring to the rematch case, it states that for the intensity, you have to take into consideration the existence of causalities, length of a conflict, and the capturing the attention of the Security Council. This is a promise we're going to execute because we're going to submit those evidences. My lords, allow me to continue with the counts. I'll first deal with the counts and then 2 counts, and my co-counsel will come with the rest of the counts and the prayer for relief. Again, my lords, the crime we're charging Major General Dragon is individual criminal responsibility of attacking protected object, and it's punishable under Article 8.2E Roman 4 of the Rome Statute and Article 28. My lords, I would like to say this because the St. Augustine Cathedral with other protected objects did not fall in any category, making it a military objective. They targeted the St. Augustine Cathedral as a protected object, not a military object, meaning that they attacked something which was under protection and not in any circumstance a military objective. The third element is that Alabasta Armed Forces led by Major General Dragon targeted had the intent of targeting St. Augustine Cathedral. My lords, allow me to continue with the last element, which is Major General Dragon, who was leading the Alabaster Armed Forces, had the knowledge that those weapons were of the nature to cause superfluous and indiscriminate effect. My lords, at the time the crimes were committed, Major General Dragon was on field, meaning that even if before going on the field, before they attacked the vendors, he was given the power to direct an operation anchor for stability, which means that Major General Dragon had an effective control. This was also reiterated in the case of Ahmad Al-Faqih al-Mahdi, where it was found that Ahmad Al-Faqih al-Mahdi was on field and had the control over the armed group that committed the crimes, and he was held liable by the ICC to be individually criminally responsible for child crimes.
Major General Dragon is criminally responsible for war crime of directing attack against civilian population, which is punishable under Article 8, 2E1 and 28 of the Rome Statute. And we stand here with full confidence and no doubt, absolutely, that the 5 elements of this particular crime are met. First of all, there was a directed attack towards the Alabaster Armed Forces and also the civilian population without separating or discriminating who is who. Major General Dragon and Alabaster Armed Forces failed to follow the rule. And my lords, allow me to take you to the most important element of this crime. First, the conduct of part of widespread and systematic attack directed against civilians. For you to confirm, or for anyone, or for this honorable court to confirm that this crime was committed, you have to prove that there was a systematic and widespread attack towards the civilian of Kuru. Your Excellencies, I would like to actually give a prayer to this honorable court that it should consider and charge Major General Dragon against the war crimes punishable under Article 8E1, 8E4, 8.2B20, and crimes against humanity punishable under 7.1B, 7.1D, and the 28 of the Rome Statute. The prosecution respectfully requests this honorable court to evaluate, and we have full confidence that it's going to do to serve justice to the whole civilians who became victims. Unless I need any further assistance from the court, Your Excellencies, I rest my case.
Thank you very much. The defense, you have 20 minutes or so to respond.
Your Honors, may it please the court, I'm Counsel Kaitesi Phoebe, and together with Counsel Derek Buziji, we represent the defense rather. Inviting your attention to the facts of the case, my lords and my lordships. The person assembled before, the very first time they entered Vendaska, they fall under a heavy fire from the LLA, but he never attacked, nor did he order his troops to attack, well knowing that the civilians were taking shelter in the civilian properties. About the duty to prevent or punish, Major General Dragon as a superior is not liable since the facts of the subordinates were justified and thus objective, not lawful, and thus the superior cannot be made accountable for not preventing or punishing. Those are the belief characteristics of our submissions. Allow me welcome my co-counsel, Buziji Derek, to proceed with the defense on their abilities.
Respectfully, my lords, proceeding in that very context, we are firstly going to justify, further prove how some elements have not been proved by the prosecution. To begin with the charge that was submitted and alleged by the prosecution on the attack on the cultural property, my lords, the Hague Convention of 1954 allows a legroom for an attack on the protected objects in times when there is military necessity. Military necessity existed because the Alabaster Armed Forces were using the cathedral to launch attacks against the Alabaster Armed Forces. By so doing,
they are gaining a military advantage from the cathedral. And when this occurs, that cathedral is transformed into a military objective, and thus it can be attacked, and it is lawful to attack it under such circumstances. It should be noted that the Alabaster forces, the reason they came to Wanu was specifically to defeat the LLA, specifically to defeat the LLA. And this attack would turn out to be the last nail in the coffin of the LLA. Therefore, the above mentions all prove proportionality of the attack, and as earlier also mentioned, we also proved the necessity. And I'll be coming back to the liability under Article 28 as it was advanced by the prosecution. My lords and ladies, it should be noted that the crime of starvation and denial of those objects does not exist in the context of a non-international armed conflict. It doesn't exist. The ICC, the crime of starvation and denial of those objects lies outside of the scope of the ICC. Further still, the prosecution may come later on and allege that there was an amendment that incorporated the crime of starvation and denial of those objects, but we wish to submit that that amendment has never been ratified, pursuant to the facts of the case. It has not been ratified anywhere. For the purpose of determining superior responsibility pursuant to Article 28 of the ICC statute, the subordinates must have committed a wrongful act fulfilling the objective elements of a particular crime. They must have, the subordinates, they're the ones we are talking about right now. Okay, thank you. Allow me to justify this on the fact that there was no actus reus, since the order of Major General Dragon to attack Vendansky was never attempted, neither did it occur, pursuant to the Mudachimura case. They never occurred, and they were never attempted. This can be revealed from the fact that the weapons themselves were not used, and there are no civilian casualties. Thereafter, he even allowed civilians to move out before carrying out any attack. All this should point to one fact for anyone paying attention, that Major General Dragon's target has never been civilians. My lords, with all respect, allow me, invite my co-counsel to proceed.
Major General Dragon is not liable under Article 7, Paragraph 1b for extermination, since the elements of the crime were not met or were not proved by the prosecution. Pursuant to Article 7, Paragraph 1b, the elements of the crimes that were not met or were not proved by the prosecution are, it wasn't intended to distract part of the civilian population, as the elements requires. Secondly, neither was it intended to kill a mass of civilian population. The target here was the LLA as a party to the conflict, not the civilian mass or population. The defense submits that the pretrial chamber court, the accused shouldn't be found criminally responsible for the alleged crimes, as the evidentiary standards are not met by the prosecution, and also due to the lack of some elements of the crimes for one to be held liable. We respectfully rest our case. Thank you.
Thank you very much, counsel. Before the defense, you have 10 minutes for rebuttal, but also judges has some clarification also. The prosecution, sorry. Though the UN Security Council resolution characterized the conflict as a non-international conflict, as you submitted in your pleading, but LLA was conducting operations on the territory of Wanu. So do you think there could be another kind of nature of conflict? And what if it was the case, what could be the impact, or maybe also what should be now that time applicable rules of HR in case there is another conflict during these operations of both sides? Thank you.
LLA conducting activities on the territory of another state, whether it will just qualify it as another sort of armed conflict. Absolutely a big no. Because even if LLA, they flew to Wanu, to a state to which they do not belong to. And because they were conducting an attack, there is no link between LLA and the state of Wanu, which means that LLA was there alone, conducting its activities alone as an armed group. Again, my lords, they brought the issue of the security of civilians, justifying the evacuation. My lord, this is not justifiable. Yes, I do agree that under Article 49 of the Geneva Convention, it stated that evacuation is allowed under the security of the citizen, but also something to add on what you should know is as military necessity imperates, apart from the security. But due to the fact that the UN Security Council is the only organ on this earth with the power to deal with security issues, the Major General Dragon should have waited for the decision of the UN Security Council to grant the permission for the deportation. And this, in international law, even domestic law, there is no justification of a crime. Instead, at least they could have said justification of acts, but still, due to the fact that they mentioned justification of crimes, they are aware that Major General Dragon committed the crimes, but they're looking for a way to escape. No, this time you're not escaping the law. My lords, on 5th June, Major General Dragon was trusted by the state of Alabasta to head the military campaign, which was entitled Military Anchor for Stability. My lords, he had a duty. Major General Dragon had a duty. Yet the defense is ignoring this duty. He already had the duty, which means he's still liable. My lords, I would like to give a word to my fellow to continue.
Let's actually look into the case in general. The Alabasta Armed Forces attacked the LLA, who were 8 years long in the state of Wanu, province of Kuru. So having been part of the civilian saving, or spending time in the same building, which is St. Cathedral or August, they went beyond that. Instead, they decided to do indiscriminate attack, which our fellow councils from the opposing side saying that they attacked only the civilian population. So what was the purpose of the siege after? As the plan B, they decided to actually to do the bullhorn technique. If you know that, it is circling the people into the center so that you would actually defeat them. So the whole siege thing was intended to bombard the whole city without thinking that there were civilians who were the victims, who were supposed to be the innocent, not involved into the fights.
Thank you. The side of prosecution. You raised the issue of alternatives, and you mentioned the alternative with respect to the use of what you are calling prohibited weapons. And I would like to ask you, with respect to the hospitals and the cathedral, and also schools which were used as the defense is contending, they were used for military objectives. Do you think there were any other alternative with respect to that?
Yes, we have to look at the destructive control and the constructive control. So what is the constructive control? It means you cannot resolve a conflict or resolve an issue by attacking the civilians. They were supposed to wait, or to give it some time and wait until the so-called LLA, army or armed group, who were actually sheltered into the schools, the hospitals, and also the churches, they would have waited for them to come on ground, for them to fight. That was a constructive control alternative that the Major General Dragon and Alabasta Armed Forces were supposed to take.
My lords, I would like to also add something about the alternative that we mentioned, which is in Article 4, Item 1 of the Hierarchy Convention. However, Major General Dragon did not respect the principle of distinction. Major General Dragon, it's stated in the facts of the case that there were hospitals and schools that were sheltering civilians, and on which LLA were bombarding the Alabasta armed forces. And still, concerning the protected objects, he had to do what? They had to wait for the LNAs to come on ground to fight, not using a worst alternative, which is even making Major General Dragon come to court, be brought to court. Thank you.
Could you help us talk about elements or principles of self-defense? Do you see any type of defense in which use of force is excused under international law as a country trying to defend itself? I would like a discussion to hear what you think about that.
First of all, my lords, LLA, the reason why they flew to Wanu is because they were facing the issue of being marginalized by the government of Alabasta and the issue of oppression. My lords, instead of fighting the government, they simply just flew to Wanu. So Major General Dragon leading the Alabasta armed forces were the one to initiate a war. It's not even a self-defense, because a self-defense will be granted if there was an attack, but LLA did not direct an attack. Instead, Major General Dragon leading his force were the first people to attack the LLA.
You know, when you look at the case, LLA, like Alabasta Armed Forces came down to LLA, and then the LLA to Kuru, and then the LLA started, they said, okay, we should attack those people, because before the fight started, Major General Dragon said that their purpose was to defeat and crush.
I want you to assess or just what the legal basis of what the HR talk about siege and what could be the impact. To what extent that siege that was linked to Verdask, what the HR say about it, about siege in general, and what could be the impact on this case. Thank you.
It requires that even if civilians stay inside, they should allow humanitarian aid to reach out to them. And they should not unreasonably withhold the consent to allowing humanitarian aid into the sieged area.
I would like to invoke Article 57, Paragraph 1 of the 1977 Additional Protocol 1, which states that in the conduct of military operation, constant care shall be taken to spare the civilian population, civilians and civilian objects. Nevertheless, the 30,000 that remained in the city of Vendaska were not the target of Alabasta Armed Forces. The target of Alabasta Armed Forces was LLA, unless you prove otherwise.
My lords, allow me proceed by addressing the issues that were raised and advanced by my land friends from the prosecution. In our submissions, we qualified our responses as crimes. My lords, allow me to respond to them through you that we qualify them as alleged crimes. The prosecution also pointed out that they are basing on a case law to invoke the jurisdiction of the ICC. That is irrational, my lords. Actually, I pray unto you that if that is to be taken into consideration, my honorable judges, it will be an insult to this court. Case laws do not provoke jurisdiction of the ICC. It is not stipulated anywhere in the context of a non-international armed conflict. And we challenge them to prove to the contrary, based on the law, not just on the case law, because case laws do not invoke jurisdiction before this honorable court. The law allows the evacuation of civilians in case military reasons demand, which my co-counsel actually proved as qualifying some to lack elements required under Article 30 of the ICC. Major General Dragon, therefore, had no duty in that context, because there was nothing wrong that was committed. There was nothing wrong for him to prevent or even punish. With that, my lords, allow me to rest our case.
I want to thank you very much for your presentation, your pleadings, and with the dynamism that you have and convincing way. So I wish you good luck for the next round. So now the judges are going to do the deliberation.
Today, on the 14th day of October 2021, the pretrial chamber of the ICC is presiding over a criminal matter between the prosecution and Major General Dragon. The chamber is presided over by myself, Judge Ndahayo Karist, and my colleague Judge Wibara Charity. Is the prosecution present in the defense? Your presentation shall be made. Your shall be made as follows. The prosecution shall have 20 minutes to present their opening statement and the charges against the charges they have against Major General Dragon, and also the defense. The defense shall have 20 minutes to present their opening statement and their defense.
The targeting of civilian, it's against international law, but it goes further than that. The United Nations on Security Council called upon an urgent meeting and adopted the resolution that all parties have to respect the international humanitarian laws. After 45 days of siege, multiple international human rights organizations reported that civilians were in their need of food, water, medical supply. But Major General Dragon responded by saying that no humanitarian aid will be allowed into the province of Kuru. Instead, he said that civilians could be evacuated in the next 5 days. Major General Dragon also ordered the Alabasta Armed Forces to bomb the cathedral. He even ordered the use of heavy artillery, cluster ammunition, which are against the international humanitarian law. Taking of bombing the whole city directly, this element is proved, saying that people who are in the Verdansk should be bombed, and by using also the material which are not allowed under the Convention of Cluster Ammunition, which have been ratified by Alabasta, which is even under Article 1, where states who have ratified that convention are not allowed to use or even produce those materials. And Major General Dragon ended up by bombing the whole city using those prohibited material under IHL.
Your Honors, defense also contends that defense prosecution has failed to present sufficient and credible evidence and fulfilling all elements establishing the responsibility of Major General Dragon, as shall be presented and submitted by the defense. Your Honors, defense also submits that the prosecution has failed to identify the nature of the conflict at hand. Your Honors, the defense submits that, according to Article 3, common to the 4 Geneva Conventions, non-government groups involved in the conflict must be considered as parties to the conflict, meaning they possess organized armed forces. This means, for example, that these forces have to be under a certain command structure and have the capacity to sustain military operations. Your Honors, in the case at hand, paragraph 2, it is evidenced that LLF forces had operated for a long time of over 8 years in the Kuru province and had turned the Kuru province into their military base. Your Honors, Article 15 bis provides that proceeding with any investigation in respect of a crime of aggression, the prosecutor shall first ascertain determination of any acts of aggression committed by the state concerned. The ICC does not have jurisdiction over the crime of aggression that the prosecution is allegedly charging with Major General Dragon. Your Honors, still quoting Article 15 bis.
Thank you, Your Honors, members of the court. I would also like to clarify and complement one thing, is that the Kampala resolution of 2017 says that its amendment to the Rome Statute that every country which ratifies and incorporate them in their laws make the court, automatically the court get jurisdiction to adjudicate over the matter related to aggression. Your Honors, in their submissions, they failed to classify the nature of conflict. So we are wondering, in what context did all these crimes committed?
Your Honors, the defense submits that Major General Dragon is not individually liable for the crime of against humanity under Article 7 and humbly requests this honorable court to dismiss the charge. The defense also humbly requests this honorable court to dismiss the charge of the crime of attack on civilians.
After hearing the defense of Major General Dragon, the bench has a question or has a few questions. I would like to know what does the law say about using schools or hospitals for military purposes?
What are the military logical and legal difficulties would you say that the armed forces of Alabasta would face, and what would be the solutions to those problems under IHR? What does IHR rules provide about the means, the methods or weapons that are indiscriminate in nature, especially during armed conflict that take place in most populated areas? For instance, the case of Fedaski.
The moment you are using a protected object to launch attack on another party, that party, it qualifies that protected object as a military objective, and it's within their right to respond, and to respond. That's the case scenario, or as we have seen it, as I invite you to read the paragraph 9, independent reports, published articles and information, and we know the role of media in this case. Major General Dragons ordered, Your Honors, in paragraph 12, not to attack, but he wanted to initiate negotiation. He wanted to see the willingness, but they refused to budge or make any sign of wanting to evacuate. On the weapons side, we are claiming that LLA was an organized with armed group with structure which has been operating in Kuru province for 8 good years, where it had the manufacture of firearms, they manufactured their firearms, even the siege itself, it did not affect them because the Kuru province was like a gold mine to them. So us using cluster munitions and rocket launchers in return, that shows that we applied the principle of proportionality. We responded by what they were attacking us with.
On the issue of the means and the equipment to be used during the war, the defense has submitted that they had enough weapons. Counsel Samuel have said that they had enough weapons for bombing the schools and hospitals, but he said they did all in their best by limiting only the electricity. Do you know how much electricity is important for people who are in the hospitals? I would like to call my co-counsel to proceed.
If it may please the court, I would like to address the issue of whether a commander can be held criminally responsible for the breaches of international humanitarian law committed by his subordinate. The issue or the case of the Yamashita case, in which was reviewed by the US Supreme Court in 1946. In this case, General Tomoyuki Yamashita, the commander of the Japanese forces in the Philippines in 1944, was charged with having failed to discharge his duty to control the operations of persons under his command who violated the law of war. The majority judgment delivered by Chief Justice Stone announced the principle that the laws of war impose upon an army commander a duty to take such appropriate measures as are within his powers to control the troops under his command and prevent them from committing violations of the laws of war. The political or military actions of the state which committed the act of aggression was in the hands of General Major Dragon. If it may please the court, the prosecution rests its case.
By the principle of distinction, as I said it, this was a province which has been infiltrated by LLA, so he couldn't tell from a combatant and a civilian. But the moment the international organizations identified 120 civilians, people as civilians, that's the moment Major General Dragon, especially in facts paragraph 5, he allowed a number of them to evacuate, because he knew now the numbers of people who were civilians, and 90,000 of them evacuated, Your Honors. That means he put in practice the principle of distinction on top of the principle of precaution.
Good afternoon. Today, the 14th October 2021, the ICC Pretoria Chamber seated in Kigali is presiding over a case of Major General Dragon. Is the prosecution present? And the defense? Yes, before you the presiding judges Charity Wibabara and my colleague Judge Karist Ndahayo. Each of the parties has 10 minutes for presentation, and then we shall give you 10 minutes of rebuttal, and you're required to go by the time. So let us now start with the prosecution.
Thank you, Madam President. Your Honors, may it please the court, the present case is of a global concern for both Kuru people and the international community. With your indulgence, Your Honors, I'll be making the first submission to this honorable court, including that a non-international armed conflict did take place in the Kuru province, starting from 13th June 2013. Your Honors, on the common elements to all crimes we are charging Major General Dragon with, there's nexus between the crimes and the NIAC. Every crime which were committed during a non-international armed conflict. To fulfill this requirement, the court in the Kalazic case, especially in its judgment, paragraph 122, found that it's sufficient to prove that the crimes took place in the context and were closely related to a NIAC. The awareness of the existence of the conflict, under this it testifies that the perpetrator was aware of the factual circumstances such as the conflict, the objective of the conflict. Your Honors, Major General Dragon knew the objective of this conflict because he intended to crush and defeat the armed group of Legions for Liberation of Alabaston. I'm going to pass over to my co-counsel, Denise Isimbi, to continue with the counts.
If it pleases the court, allow me to proceed with count 1. The prosecution is charging Major General Dragon, and that is a war crime of attacking protected objects under Article 8, 2E4 of the Rome Statute. On the protection of cultural property, clearly defines that a national cultural heritage, a national cultural property is of great importance to national cultural heritage. Your Honors, Additional Protocol 1 at Article 85 defines acts of attack on clearly recognized historic places of worship, which constitutes a cultural heritage and to which special protection has been accorded as a crime. Your Honors, it should be noted that the St. Augustine's Cathedral was not used as a military objective. I quote from paragraph 12 of the facts of the case. Major General Dragon ordered his troops to attack the cathedral, but given the unwillingness of the LLA to evacuate the cathedral and the central strategic location of the cathedral for controlling the rest of the city and for the use of weapons stored in the close-by arsenal, the Alabaster Armed Forces bombed the cathedral and the arsenal after 3 days. Your Honors.
Your Honors, on count 3, we urge Major General Dragon should be tried for a war crime of attacking civilians under Article 8(2)(e)(iv) of the Rome Statute, and all elements are fulfilled. Your Honors, it's in this regard that Major General Dragon bears a criminal responsibility for ordering an attack under Article 25(3)(b) of the Rome Statute. Thank you, Your Honors. With the time interest, we would like to submit to this honorable court our prayers for relief. The prosecution humbly prays this court to adjudicate and declare that 1, all claims are admissible. There is sufficient evidence against Major General Dragon in the charges below, including that Major General Dragon is criminally liable for concerning the attack of St. Augustine's Cathedral, especially under Article 28A of the Rome Statute. Secondly, Major General Dragon is individually liable concerning the attacks on hospitals and schools, sheltering sick and wounded civilians and all combatants under Article 25D of the Rome Statute. Finally, Major General Dragon is criminally responsible for the bombing of a Dasker under Article 25(3)(b) of the Rome Statute. Respectfully submitted by the agents of the prosecution. Thank you. Your Honors, he should have taken the principle of minimizing casualties. Your Honors, it was justified. It was not proportionate, Your Honors, because we find by independent reports, especially in Facts 9, where we find independent reports saying that civilians and soldiers were killed. Thank you.
Now we go to the defense. You have 10 minutes to present your opening statement and defense for Major General Dragon. The floor is yours.
My names are Kanso Umuhuza Faraja Judith. I'm with my co-counsel Idahosa Ginen. First of all, I'll be addressing the preliminary matters, and my co-counsel will come addressing with the defense on crimes. The prosecution has a task to give sufficient evidence to establish substantial ground to believe that Major General Dragon committed the crimes. My lords, the prosecution did not prove that the LLAs are the armed group. Hence, and even if you look at the qualifications of an armed group, they do not even fall in the category of an armed group. Instead, we recognize LLA as the terrorist group, which were attacking, which due to, if you look at the facts, paragraph 2 of the facts, it states that LLA used to direct attacks, apart from manufacturing weapons, used to direct attacks to the province, to the state of Alabasta. Pursuant to Article 2B of International Convention on Suppression of Financing of Terrorist Group, they define terrorism as any sort of act which is done to intimidate the population, to intimidate the government, and to the government to do any certain act or refrain from any act.
Your Honor, if you may please the court, my name is Gilen Irahoza, and I'm first going to respond to the prosecution allegation whereby they're accusing Major General Dragon the crime of attacking protected objects. Your Honor, as we all know, if a protected object is used by a certain armed group or any armed forces to shelter or to direct attack against the other party, it is no longer protected under the principle of imperative military necessity and the principle of proportionality made the attack on the church lawful. The attack that the Alabasta armed forces made on that church was very lawful. This is in accordance with the conventions of 1999 Second Protocol. As an addition, military necessity corresponds to the customary criteria of the necessity and proportionality, and as a herenda justified with the regards of the fact in the case as good days intends for the ground battle. And I would say that Major General Dragon was not aware of what was taking place. What he knew that the population in Kuru needed to be protected against the terrorists who were hiding amongst the civilians, as my co-counsel Faraja earlier mentioned. Pray to this honorable court to adjudicate and to handle this case, to charge Major General Dragon for to relieve Major General Dragon of the allegations made by the prosecution. I rest my case.
The question goes to the defense, especially from the submissions of the first counsel. When you're talking about jurisdictional court, you mentioned the immunity that Major General Dragon holds, being an official of the government. How do you relate that statement in relation to Article 27 of the Rome Statute?
Major General Nezar was relieved of the criminal responsibility under a foreign court. Major General Dragon, the ICC is not his national or domestic court. It's a foreign court to him. So according to what happened to Major General Nezar, I believe that it should be equally applied to Major General Dragon as well.
Your Honors, it is said there has to be the immobilization of armed groups. Your Honors, according to the facts, paragraph 4, when LLA, Alabasta Armed Forces entered the province of Kuru, they were welcomed by fire. We are talking about here about grenades, rocket launchers, among other weapons. And they had even to retreat. This shows how they were organized as a group to plan and carry out attacks. And this is one of the elements which establishes if a group is armed in more than a terrorist group. Your Honors, we have the independent reports of international organizations, the media, who were present during Operation Anchor of Stability. And their sole role was fact-finding and providing the numbers. The UN Security Council and a resolution was passed on it. Your Honors, this is not an isolated case. Your Honors, they also said we did not satisfy the elements. I would like to bring to this honorable court, they did not specify which elements we did not specify because we gave them 5 full elements. It's up to them to point out we are not satisfied with this element and bring it to your attention. Your Honors, allow me to call upon Denise Isimbi to continue with the rebuttals and the closing arguments.
If it pleases the court, allow me to proceed. Your Honors, the defense came arguing about the jurisdiction of the ICC over the counts of the crimes, the war crimes that were committed in the Kuru province during the operation of Anchor of Stability. The fact that defense argues that Major General Dragon deserves immunity does not suffice. Your Honors, as quoted in Article 27 of the Rome Statutes, it does not suffice in a way that the people acting in official responsibility cannot be granted immunity. The superior knew or had reasons to know that the subordinate was about to commit a crime. Your Honors, this is a crime that was committed by the Alabastan forces against protected objects. He did not stop it. He just watched and celebrated the victory when the bombing was over. Your Honors, the superior failed to take necessary or reasonable measures.
Your Honors, I would also like to compliment my co-counsel Denise Isimbi. In relation to military structure, they said Major General Dragon had no awareness of what was taking place during Operation Anchor of Stability. Your Honors, in the ICRC commentary on Additional Protocol 1, it observed that there is no part of the army which is not subordinated to a military commander at whatever level. Also, Major General Dragon, the actions taken by the Alabasta military forces in response, Your Honors, this shows that Major General Dragon felt confident and knew that as a commander that the military forces would carry out the attacks. Thank you.
Thank you, Your Honor. Major General Dragon is not criminally responsible for ordering crimes against humanity. Lack of material element for the order, dear honorable counsels. In Mudachumura case, the court establishes that for one to be found liable for ordering, he must have used his authority, prompt another person to commit the crime that occurs or is attempted. Honorable judges, the prosecution has a duty to give out the elements, to bring out, like, for there to be a crime, there has to be what prompted it, what induced it. They have failed to illustrate on that, honorable judges. I would also like to give a mic to my co-counsel to say something. I raise my case.
Thank you very much again. I would like to address the issue that they brought concerning the case that we talked about concerning the immunity. International humanitarian law is not only composed of the treaties, it's also composed about customary international law. St. Augustine Cathedral is falling under the categorization of a military objective due to its use. Then when it lost its protection due to it being a military objective. Again, the military necessity second condition, it says the alternative. My lords, there was no alternative. There was no alternative. Instead, because we had to use that. LLAs were a terrorist group and we had to get over it. So we had to do each and everything possible to stop it. Again, Major General Dragon will not be held individually criminally responsible for the crimes because the elements for fulfilling the command responsibility are not fulfilled. My lords, the prosecution failed to give sufficient evidence because even if they gave evidence, there are not evidence matching the crimes. There are evidence maybe for something else, but not the crimes they're charging. Even if the prosecution had the task of proving the alleged crimes, as long as they did not do that, Major General Dragon, he's not criminally, individually responsible for the crimes. Thank you.
The court has carefully followed the prosecution charges and submissions, the defense of Major General Dragon, the closing briefs, and we hereby want to dismiss this court hearing so that the judges can make deliberations. The pronouncement of the judgment will be on the 14th of October, 2021.
So we are pleased to receive you before this pre-trial chamber. In the case, the prosecutor against Major General Dragon.
My lords, allow me invite you to the facts of the case where it was stated that indiscriminate attacks were carried out on a civilian village of Vendansky. Further still, they committed, Major General Dragon committed a crime of starvation on over 120,000 civilians, and further still, he laid siege and denied humanitarian aid to enter the city, which was composed of 30,000 civilians. Weapons that were used were totally indiscriminate. The other question, my lords, that was raised in the case was the question of whether the accused is most responsible by his actions and omissions. My lords, I invite you to the facts of the case where Major General Dragon ordered the attack on a shopping center, which was not used as a military objective. Further still, he also ordered the attack on the city of Vendansky with unguided munitions and prohibited weapons. The conflict at hand happened on the territory of a state party, that is number one. It also, the crimes that were committed by a citizen of a state party. And thirdly, the crimes that we are prosecuting Major General Dragon are those crimes that are punished under Article 5 of the ICC Rome Statute. And further still, the crimes that were committed in 2013 after the coming into force of the ICC Rome Statute on a civilian village. These are the weapons. It is thus our humble submission that you take this into your highest consideration in charging the accused. Thank you, my lords. Let me invite my co-counsel to proceed.
Thank you, Your Honors. Pursuant to paragraph 12, on his order not to bomb what was left of the cathedral is a prima facie proof of his knowledge of the status of the cathedral. He should be held liable under Article 25B for ordering indiscriminate attack, which in fact occurred, causing the damage on the cathedral. The accused ordered indiscriminate attacks on the whole city, composed of 30,000 civilian population. And it lasted for 4 good days, my lords. That the ICC has jurisdiction over the case, that the case is admissible, that there are substantial grounds to believe that Major General Dragon is liable for all counts. We rest our case. Thank you.
Thank you, the prosecution. So the defense also, you have 10 minutes for a response.
The jurisdiction and admissibility, the legal issues, and the crimes against humanity. My co-counsel is going to continue with the war crimes, and she's briefly going to talk about the command responsibility, which was mentioned by the prosecution. On the 5th of June 2013, the declaration of the military campaign by the Alabastan called Operation Anchor of Stability. On the 10th of June 2013, the operation was conducted in the province of Kuru, in the territory of the neighboring state Wanu. However, none of the crimes on Article 5, as mentioned by the prosecution, were committed by Major General Dragon. Now, when it comes to admissibility, as a precaution, in the event the court finds itself with jurisdiction, the defense submits that the pretrial chamber shall determine the case against Major General Dragon as inadmissible by way of complementarity of Article 70 of the ICT, how this case got to court. Moreover, I would like to address the legal issues at stake here. Or, not to be long, I would rather go straight to the crimes against humanity. For the element of a direct attack, it means that the civilian population must be the primary target of the attack and not just an incidental haphazard victim of the attack. Furthermore, since Major General Dragon made an alert before the bomb, then they should not punish for the bombing because they provided a chance for the evacuation of civilians due to the fact that the opponents used cultural and civilian buildings, then made the military necessity. It is important to remind to the court that the defendant did all that was in his power in order to minimize and limit any civilian losses, such as ordering the evacuation of the city. And this demonstrates that there was no intention to involve or willfully kill any protected person.
From the fact of the case, it's clear that Major General Dragon ordered the evacuation in the next 5 days, so that civilians could move from one place to another in order to be protected. Even Major General Dragon did not launch an attack against the civilian population. The attack was against LLA only, not the civilian population. This court lacks jurisdiction and admissibility of the case, as it has been proven, and we declare that Major General Dragon did not commit any crime of the violation of the ICC statute, and that all charges submitted by the prosecution should be dismissed due to the lack of the evidence to be proven. Thanks, Your Honors.
My question is for the defense team. One of the assertions of the prosecution was that there was an international armed conflict, and at the same time there was a non-international armed conflict. Do you have any challenge for that? And can you state your reasons for your answer?
A non-international armed conflict is an armed conflict in which hostilities are taking place between the armed forces of a state and organized non-state armed groups, or between such groups. For hostilities to be considered as an act, they must reach a certain level of intensity, and the groups involved must be sufficiently organized, as it is the case.
How do you assess that, and what would be the difference in a case this conflict was an international armed conflict?
Can you please elaborate more on that? Can you explain how this court does not have jurisdiction and what was supposed to be done? How, what are the trigger mechanisms for the court? Elaborate more on that.
Basing ourselves on Article 17 of the ICC and basing ourselves on Abu Garba versus the ICC. Now, regarding the trigger mechanisms, there are certain conditions under which a case has to reach to court. First and foremost, it must be referred by a state party. Secondly, the investigation by the prosecutor must be proprio motu. Thirdly, the referral by the United Security Council should be written. This is justified by Article 13 of the ICC. Are still allegations the prosecutions are making, and thus could not be, Major General Dragon could not be considered as a criminal. Thus the reason why we say this court don't have jurisdiction.
Okay, so the prosecution have 10 minutes also for the rebuttal.
Thank you, Your Honors. Yeah, to start by on what the learned friends from the defense talked about the starvation of civilians. They talked about that they granted 5 days for the evacuation, but we still prove that there had remained 30,000 civilian population in the city of Vendaska. How about them? Crimes against humanity were committed when Major General Drogon ordered indiscriminate attacks and use of indiscriminate weapons on the whole city. He's still liable under Article 25 for the ordering and Article 28 for not preventing or punishing. Allow me to invite my colleague to proceed with the defense.
Thank you, Co-Counsel Kaitesi. Allow me proceed, my lords. Firstly, responding to the issue of the nature of the conflict, my learned friends from the prosecution advanced that they claimed that it must be between two states. Yes, we agree to that. For an international armed conflict to come into play, it must be between two states. I invite you to Article 2 of the Geneva Conventions, which stipulates that even occupation is an international armed conflict. So even if it does not meet with armed resistance from the attacked state, it still amounts to an international armed conflict. So it should be concluded, and I pray and submit before this chamber that they should confirm that the threshold of harm for an international armed conflict to come into play is very low. The attack was directed on a civilian city. He told them to attack Vendaski with unguided munitions, multiple rockets, and cluster munitions. All these were directed against the city.
Good afternoon once again. What a wonderful day. I know for some it has been long and tough day, but we are so happy that we are at this level. We are at the end of this day, but we continue tomorrow. So I know so many are waiting to know who's continuing tomorrow and who's just is going to wait to claim others. All teams deserved to be here, and we were discussing between ourselves how the level, if we compare to previous sessions, we can see that this year the level is really on high. There are some achievement and some improvement on how the memorials are prepared, how you presented your submissions. It's really something that is encouraging, and we want to thank you and congratulate you all for this, how you were prepared. Those who are not going to participate at the final round, it doesn't mean that you don't deserve it. It's just a competition, so there must be the best performer, and the second, the third, and then the fourth. That's how the life is. For the two teams that are going to the finals tomorrow, there is team D, URK, and team C, UR. Those are the two teams that are going to the finals tomorrow. We see that we have candidates already that we can integrate in our teams in the future years. So you have the best future in front of you. We see that we have good lawyers in the coming. So keep it up, and maybe some may continue in this field of international law. Others may be in public law, just or civil law here in practice. But you have potentials, and I really want to congratulate you all for what you have done and what you showed us today. We are so proud, and your lecturers and the coaches should be proud of you without distinctions.
I have a few advice and suggestions that I think might be useful for you, for those preparing for tomorrow and even for later competitions with other countries. As a student, I was also a Moot debater, and I was a very vehement competitor. And sometimes I lost, sometimes I won. So I understand clearly where you are today when you're standing in those places. I've been in all those roles. So, and I've been privileged to learn along the way. So, and never count it as a failure, just count it as something that is an opportunity to learn and to be better, okay? So some of the things that I observed, when you're standing before court, you have to be aware of how to address the court. I think the presiding judge spoke about it. Sometimes you called us your excellency, sometimes you called us my lady and my lord. Some of those are not appropriate titles to address the court. So find out what the particular court is expects and use that. In English, in the English world, it's always safe to say your honor or your honors or my lords, and that's it. You do not need to call a judge my lady. That's a different meaning altogether, okay? So the way you address court is extremely important. Number two, it's your posture. Sometimes you have very good argument, but the way you're slouched over, you don't give an opinion or a visible sign of self-confidence. So when you're like this, even if you are speaking very good arguments, people will just, body language is extremely important. So I was seeing some of you, you kept your notes down and you kept bending over to read. So that's not good. First of all, learn to memorize your work. Learn to be able to know and argue your points very well. Number three is you're trying to convince the court. Okay, you're not trying to convince your opponent. Okay, many times you look at opposing counsel as a person that you're addressing. You're like, you said this. In fact, it's like this and this. No, you're not trying to convince those people. Establish eye contact with the court. Look at the judges because they're the people that you're trying to convince. The other thing is that for your arguments, it's always good to tell a story, a convincing story. You need to believe in what you're saying, but just don't say a story. Don't talk about your feelings. Don't talk about things that are there. What is important is the law. I noticed that most of you are citing the law, you know, Article 28, and you go. And then you talk about your story. No. Tell the court what that article says, and then base your argument on that article. Read it emphatically. Let the court know you're basing on this article or a provision of the law, and you're not just citing it as a by the way. It is the basis for your argument. So do not start with a long argument and then cite the law at the end as a by the way. Read the law and emphasize it, and then make your point relate to that law. But the law should be the prominent, not just the story. I think those are some of my things, but otherwise, generally, remember those for tomorrow and for later competitions. I think if there's my colleague who wants to add something.
Thank you very much. Me, I have a few remarks. First of all, I also want to congratulate each and everybody of you. As you see me here, one day, sometime back, I was like you. So when you are doing this, understand that this is the beginning of the best future. I am the pioneer of the first IHL Moot Court in Rwanda. We were the team that represented Rwanda in Arusha. So I understand your position, I understand the nervousness, everything that happens here, I understand them. One of the things that my colleague mentioned about was the confidence and the body language. Whenever you're presenting your arguments, always have the confidence. Show the court that you have the confidence in what you're saying and you know what you're saying. If you fidget or have some nervousness and you let it show it out, and then you have to know you will lose on the way. Either you will forget the facts or you forget the law. So always emphasize on building the confidence within you. Another thing was respect of time. You have to understand this is a competition. Even in practice, they require us to respect time. If they give you time, you have to respect it. Another thing is you have to know the law. Most of you, there were a few of you who made some mistakes. That is okay. But for those who are going forward to the finals, and even for those who made mistakes, you have to understand that you have to understand the law. If you're not sure about something, don't mention it. Because if they find you, it might be a penalty instead of being an award. on answering questions, when the judge asks you a question, you don't have to skip the question. If they ask you a question, you have to answer the question before you move forward. If you cannot answer the question, talk to your colleague, to a co-counsel, and see whether they can answer the question. And then let them answer the question, and then you proceed. Instead of saying, I'll come on it late after. Because the judge asked you with an intention. The judge always has an intention why they're asking the question at a particular moment. So try as much as you can to answer questions, unless if you don't have an answer, both of you. So always make preparation and do not read from what you have. Have outlines. Come and stand and present what you have already you know. That will help you and will give you marks. Thank you very much. I wish you good luck.
So maybe to add one last comment that will maybe also help the team tomorrow. The way the sharing of work was done for some teams, if we are 2 counsels in one case, and you see that one is speaking out of 20 minutes, one is using it 18, and the other one is only using 2, doesn't show a good teamwork. So try to share. I know each team might have one, the strongest reader, and the other one, but please try to share and also balance so it can create that dynamic. See that the case has been prepared by both of you, and also each one has a role to play in it's not necessary to have 10-10, but it can be 12-8 or 11-9, but there must be that balance between both of you. So I think that's all for tonight. Go and prepare well. So, and see you tomorrow. Thank you, and I wish you good luck.
Before we end this event, we would like to welcome the representative of the Rwanda Red Cross, Mr. Placide. Please give him a round of applause. Thank you very much for joining us today. I would also want to welcome Serugo Jean-Baptiste, an international, yes, Jean-Baptiste, thank you for coming. He is a lecturer from the University of Rwanda, the International Humanitarian Law lecturer. We also want to welcome Dr. Zikamabahari, the Dean of Law Faculty at University of Kigali. Thank you for joining us. And finally, would like to welcome Maître Valérie. Thank you very much for coming. Now, thank you so much, judges. I'm sure we appreciate all their work. Now let's hear those claps. Yes. Give them generously. And congratulations to the winning teams. Thank you all for participating. And we are proud of the winning teams. We are proud of the rest of the teams as well. My name is Wamge Ziroda. It was lovely hosting today's event. Tomorrow is the last day, and come in full motion. The day starts at exactly 9 a.m. And yes, let's see each other tomorrow. Thank you once again.